Here we go. My name is Andy Ayers. I'm the director of the Government Law Center and a visiting assistant professor here at Albany Law School. I'll be co-moderating tonight's discussion. As you know, every year Albany Law School honors Kate Stoneman, who was the first woman to be admitted to the New York bar, in large part due to a campaign that she orchestrated to make that possible, and who graduated as our first woman graduate in 1898, 119 years ago. Every year we give an award to someone for bringing about change and opportunities for women in the legal profession. Nobody could possibly deserve it more than our guest this evening. Born in the Bronx in 1954, she graduated summa cum laude from Princeton University. All right. She went to Yale Law School, where she was an editor of the Yale Law Journal. Yeah, I see one hand pumping in the air. She was an assistant district attorney in Manhattan and in private practice for a few years. All right, we've got one of those too. And she was nominated to the United States District Court for the Southern District of New York by the first President Bush, to the Second Circuit Court of Appeals by President Bill Clinton, and to the Supreme Court of the United States by President Barack Obama in 2009. She'll be joined tonight on the panel by our president and dean, Alicia Willett. Please join me in welcoming Justice Sonia Sotomayor.
You know, Andy, you get into this position and you learn how to give up not liking yourself in pictures. Many of you may know I was once married, and at my wedding back then, you paid for the pictures you got, 100 of them, and it was a package fee. At picture number 68, I told the photographer, go away. I've stopped doing that now.
Well, Justice, we are so happy to have you here. It's really an honor of a lifetime for every member of the Albany Law School community to welcome you here, and we are especially glad to have you here as we celebrate Kate Stoneman Day, which is a day in which we honor women who make a difference, who take chances, are bold, and change the world for the people who come after them. Particularly for women and people of color, and we just think that adding you to that legacy makes us a better place forever, and we're just so grateful to have you here. And we have a tradition on Kate Stoneman Day of having a keynote address. Our keynote address this year will be a little non-traditional. We're going to have a conversation. And Andy and I will start out by asking you a couple of questions, and then we've got some students who are eagerly waiting the opportunity to ask you some questions as well. So I'd like to start by asking a question about personal style in both your public appearances in your book and your judicial opinions. In your public appearances and throughout your book, which I loved, and I hope you all buy and read. It's really wonderful. You share your vulnerabilities. You talk about struggles. You talk about your imposter syndrome at times. And you share your big personality. In your judicial opinions, you are incredibly professional, brilliant, of course. But there aren't the rhetorical flourishes in the same way that we see in your book and when you talk in public. And we start to see a little bit of that when you write dissents, a little bit of your personal style in the recent dissents. But I'm wondering what your thoughts are on the tension between sort of your public persona as a vulnerable, strong, but very, very human justice, and your personal style in your judicial opinions, and if in these dissents you are starting to develop more of a personal style in your judicial dissents.
Well, Dean, when my book came out, Nina Totenberg, who's a commentator, famed commentator for NPR, read the book and she interviewed me. And one of her initial observations was that my book read like fiction. And then she said, why don't you write opinions like that? And I looked at her and I said, because it's not fiction. It's a simple answer. But opinions are real life. And opinions are about making pronouncements that deeply affect people. And to the extent that that is what an opinion is doing, I feel an obligation, especially when I'm writing for the court, because it's a capital T and a capital C, to ensure that our voice is not the voice of fiction and not the voice of emotion, but the voice of explanation, of really explaining how we reached our conclusion and what in the law compelled the answer we gave. And so to that extent, and I've mentioned this to some of the students I spoke earlier to, I work very hard at making my opinions understandable to anyone who bothers reading them. I'm laughing only because in this room there are mostly lawyers. How many lawyers in this room have actually read a Supreme Court decision from cover to cover when it's come out? Not half the audience. Most people don't read our decisions. Most people form their opinions from popular press, from reports of what we say, all right? But I want to ensure that anybody who picks up one of mine, if you took the legal sites out, you don't need more than a 5th grade education to follow what I'm saying. And I hope with most of my opinions that I've taken you through the logic of how I reach my conclusion. By the time you get to the last page, I hope you can say, now I know why I should rule this way and why you should rule the way I want you to. Now, it doesn't obviously mean the same thing when you're a dissenter, because you're not speaking for the court. You're speaking for yourself and what you believe the court has gotten wrong in its analysis. And there you can have a more personalized voice, but even with that personalized voice, you have to be careful, because if you want other people to join you, you can't go so far to the extreme that the verbiage of your opinions will turn people off from joining you. I've had more colorfully written colleagues, writings by more colorful colleagues, and you will notice in many of those instances that people will forbear from joining their dissents or might write separate concurrences if they're in the majority, because they don't like the expression of how that person is saying things. And so you're always sort of walking that fine line as a justice. If most of you will see almost any dissent that I author, there's probably 2/3 of it, this is my formula, where it's pure legal analysis. I show why the majority got it wrong. Only the last third tells people why it's important, meaning what the consequence is of the wrong decision. And I do that because I do believe that laws affect people. And one has to acknowledge that when you're writing and telling people they've lost. You have to make them understand that they were heard. So even if they're losing, that they feel that their statement had some value. But I do believe that it's a different vehicle than a book. And to the extent that any justice grows, and every justice should grow and does grow, I often tell the story of my first year with Justice Stevens. I called him up one day after reading one of his opinions and said to him, John, I'm in awe of you. This is just a brilliant opinion. And I'm a little frightened that I could never do something like this. And he paused and he said, Sonia, no one's ever born a justice. You're born a person. You grow into becoming a justice. You have all the tools necessary to make your own mark. And I was eternally grateful to him for that first year, because I spend a lot of time trying to improve my work as a justice, and I realized that that's a natural progression in growing, which is, I hope my opinions will become more engaging, more readable, more everything as I'm a justice for longer.
Thank you.
So my question picks up on one of the first conversations we ever had about 15 years ago. The very first piece of writing that I gave you, I drafted something, and you said, take it back and do it again. This isn't right, because you haven't been fair to the losing side. You said it does a good job of articulating the argument that's going to win, but it doesn't do a good job of articulating the argument that loses. And you said, I want you to think about judges as public servants whose clients are the public. And I took that with me when I became a government lawyer, and now that I teach professional responsibility, because I think that for a lot of people who go into government, and a lot of Albany Law students do go into government, figuring out who the client is can turn out to be an amazingly complicated question. For a prosecutor, at least you have a specific ethical rule that tells you you're supposed to do justice, so you can start from there. But for somebody who's a government litigator representing an agency, is it the public? Is it the agency? Is it the people at the agency who certainly think they're the client often? And if so, these different candidates for being the client all have a claim on you and your loyalty. So I'm wondering if you have any advice for, you certainly see plenty of government lawyers in your current position and in your other jobs as a judge. So how do you recommend people think about this question as they go out into practice?
To answer that you're a lawyer for all of them, which it feels contradictory. In certain moments it may well be contradictory, because there's always competing interest in claiming or clamoring for both attention and for position of precedence, okay? But the reality is that unlike a defense attorney, whose role is always well-defined, it's the interest of your client. But even then, and I talk to defense attorneys about this, particularly when they're arguing before the Supreme Court. Yes, your paramount interest is your client, but you better figure out how to harmonize their interest and the interest in the development of the law before you come to the Supreme Court. Because our job is not to protect your client. Our job is to develop the law in the right direction. And to the extent that your arguments are asking us to take a wrong step, we're not going to listen to you. So you're going to lose just because you've forgotten what our purpose is. And you haven't crafted your argument to take us to a place where we believe the law would develop properly. So that's where you're trying to attempt to get us to go. So just that answer gave you a clue, which is if you stop and realize as a government attorney, you represent a very fractured society. And not fractured because that's the nature of our country today, but fractured because we're a community, as is every community in the world, with competing interests. People have competing interests, they have competing needs, they have competing passions, they have competing drives. We are different. What law is trying to do and what government is trying to do is to harmonize those interests along lines that we can live with. Not ideal lines, because ideal lines would have endless resources that would satisfy everybody's needs, but we don't have that. Endless lines would have people not compete. If we had the ability to tell people, your needs are great, so are mine, and why don't we shake hands? Well, it doesn't work because sometimes needs are so competing that we can't do anything about it. But when you're a government attorney, what you're trying to do is to promote that harmony within a position in court that will promote the needs of all of those groups to the best ability, to the best of your ability as a lawyer. To give intent, or to have judges understand what the intent of the law was, and to give effect to that intent. Because virtually all laws are written for a reason. Legislatures don't get together and say, we want to do X because we want to. Or we want to do X because we think it's okay today, and tomorrow we'll do Y. They have a set of priorities that generally develops from needs that are being expressed within their community. And they have solutions, often that are not ideal, because they've been compromised into imperfect solutions. But they have an intent about what they hope the law will do. And it's judges and lawyers that give the bones to that intent, that give it a meaning. And so if you start with trying to figure out who you represent, you'll get lost in the morass. I think you have to, as a lawyer, step back from it and figure out what it is that the law intends, first and foremost, and then try to bring those other competing views into line with an answer that moves the law forward in a positive way.
Thank you for that. We're going to have a great talk about that in my PR class on Wednesday. Thank you.
So one more question from us, and then we'll turn to the students. So one of the things that I love to hear from judges about is what they find to be especially hard. Are there cases or categories of cases that keep you up at night, that are especially challenging? And you have been a judge at the district court level, the circuit court level, the Supreme Court level. Does it make a difference at what level you're judging in answering that question?
As a district court judge, sentencing decisions are the ones that I think keep most trial judges up at night. It's the one where the direct impact on a defendant and his or her family is most vivid and present for a judge. So to the extent that in every sentencing decision, every judge is receiving a pre-sentence report where that defendant's life has been gone into since birth, basically, and the impact of your decision, not just on the defendant, but on everybody involved in the case, including the victims, but the defendant's family, defendant's workplace when there is one, community at large. All of that is, and I think does, prey on almost every single judge. On the circuit court, a good percentage of the cases we dealt with were answered by existing precedent in an almost direct way. The principles of precedent, the issues that came before us, seemed to fall fairly cleanly into the clear parameters of those principles that had been set by the Supreme Court or by circuit precedent, because that's how circuit court judges rule. They look at what the Supreme Court has said first. They second look at what the law of other panels, prior panels on the circuit court have decided, and decide that issue. You get tortured by those cases for which there is little precedent, or for which precedent exists, but it's not really firmly guiding an answer in one direction or the other. And those cases can keep you up at night. When you're on the Supreme Court, all of the cases are like that.
Yeah, you're not sleeping much.
No. If you recall, the United States is divided up into 13 circuit courts. Those 13 circuit courts cover all of the district and territorial and lower courts of the federal government. And every legal issue that arises under law comes up and percolates through the circuits, so that one legal issue can be visited by all 13 circuits. Now, we don't generally wait on the Supreme Court for all 13 of the circuits to speak. We wait, however, always, or almost always, for a circuit split. That means that a good number of the courts below and a countervailing number of the courts below, and it doesn't have to be equal numbers, but a fair number of both, have taken the identical legal question and come to different answers. Now, if you start from the proposition I do, which is that most circuit court judges are trying real hard to get it right, that they are, by definition, because they've been well trained in the law for a long period of time before they got on the circuit court, and that most of them wouldn't have gotten to the circuit court unless they were respected. Because remember, it's a presidential nomination, and they're subject to strict scrutiny. Pardon the term, not in its legal sense. That those circuit court judges are disagreeing because there's a real problem in getting at the answer, that it's not crystal clear. And that makes every single case we take a Supreme Court case. And it makes it hard. Yeah. And the other thing I didn't appreciate as much before I got to this job was I had not recognized how much easier it was to come to decision-making as a district and circuit court judge because I knew I wasn't on the final court. That if I really, really got it wrong, there were at least one or two courts above me who could fix my mistake. There's no court that fixes our mistakes now. No. And Congress can fix some of the interpretive mistakes we make with respect to laws, but that's a very hard process. It happens on occasion, but not with the kind of frequency that helps all of those people affected by bad decision-making by us. And I shouldn't say bad, erroneous decision-making by us. And so I had not understood how terribly hard this job would be. Much, much harder. And it's every single case. Because in every case, I realize that no matter how right I feel my vote is, and I don't vote unless I think it's right, no matter how right I feel the answer I've given is, there's a loser. That's what Supreme Court cases are about, deciding who wins and who loses. And I can't help but know how the loser will suffer. Because before the Supreme Court, every single case we get a pre-sentence report from the world. We get amici briefs from every interest group that will be negatively affected by our decision in any way. They file an amicus brief telling us exactly what the bad things that will happen to them. And that makes the job very hard.
Sounds like it.
So our first student question comes from Charlotte Rafus, actually. Give you a mic.
All right, let me tell you what I'm going to do. Surrounding this room are men and women standing up in uniforms. If you look closely enough, they got little things in their ears. They're here to protect me from me. I like walking through the audience. I get bored sitting down. And more importantly, I think it engages you more if I walk up to you and say hello, but you can't jump up unexpectedly. Because it scares those guys. And they'll pull me out of off the audience and back here. So I want to be among you, so just sit. I do give an occasional hug. Sometimes it's because I recognize somebody. Don't be jealous, okay? But I will walk around. I hope that the audience in the overflow room gets to see me. Tell somebody if you don't, and I'll come down a little further, okay? So, hello.
Hi.
How are you? There's one thing I'm going to do is take a picture with all the students who ask me a question. So, ask your question. Go ahead.
I don't have a list.
So, my name is Charlotte Rafus, and I'm a second-year student here at Albany Law School. So on a daily basis, I am striving towards being confident and standing my ground without compromising my relationships with others. In doing so, I am trying to find the balance between appearing assertive and confident without being perceived as aggressive or abrasive. As a woman in the legal field, how have you dealt with double standards, and how would you advise young women as we enter our legal careers? Thank you. Thank you.
Now, I'm not the best person to be asking this question of, because I've been called abrasive and assertive and nasty and a couple of other adjectives. Every time people say that about me, I go, me? I've learned through time, and it's taken people pointing it out to me, that when I get caught up in legal argument, I will stare at you, but I'm not staring at you because I'm trying to play tough with you or to make you feel uncomfortable, but because I'm trying to listen to you. And my mind is working and trying to figure out what you're saying and why. And that stare, though, becomes menacing to people. So much so that I disclosed earlier that during my preparation for the Senate confirmation hearing, the people who were prepping me were telling me to look away periodically, that I was way too intimidating and seemed nasty when I did that. So I had to train myself to look away and to start taking away from that. But I still do it in the courtroom. I still sometimes find myself sort of engage with people in a way that makes them feel uncomfortable, okay? So don't take my answers as the answer, all right? But I'll give you the best that I've come to, all right? Some of it I learned from having a teacher who I co-taught with when I was a judge. And he taught me that one of the approaches that teachers have is that whenever you do a performance, the first thing the teacher will do is compliment you, even if you blew it. They are taught, to look for the best thing that you've done and to shore that up and to tell you all the positive, whatever you did. The same thing with an answer you give. Think about when it's not a pure Socratic teacher, when it's one with more sensitivity, okay? That teacher will sit there and pull apart the best things that your answer gave, what you recognized, what insight you had that was better than other people's might be. Hello. And they will tell you that first, and then they will pivot into the things that they need for you to learn. And so they'll pivot in a way that engages you in understanding the weaknesses in your presentation. Well, I have found that that formula works in about everything you do in life. If you listen to people very carefully And listen not just to what they're saying, but what is motivating what they're saying. What their emotions, what are the emotions that are driving them to their position? In other words, what is that person feeling? What's raw for them? And makes them take the position that they're taking. If you can identify that spot and you lead off acknowledging that spot and not denigrating it, but explaining to the person why their own spot is important and legitimate and needs recognition, and then pivot to how whatever solution you have gives them that, even if they didn't know it. That's been my formula for success. And that's why when I spoke to Andy that time, when that first assignment, I said to him, we do have to explain what our reasoning is, but we're going to leave the loser unsatisfied if we don't acknowledge their point. And not in a way that says it was a stupid argument, but in a way that acknowledges the strength of what they're saying, but then points out why it can't win the day in law. And so I do that almost as a formula for my opinions, but also for my formula for life as a woman and as a lawyer, which is, yes, learning how to be assertive means first that you have to understand your own position, its strength and its weaknesses. But equally, you have to understand the positions of your adversary and acknowledge their strengths. Because if you can respect someone else's position, it doesn't show weakness, it shows human understanding. And I think that people find that valuable. That's why most people like women. That's why they think we're nurturing. And it's why it's a strength that if played properly, if you can get to the place where you can admire yourself for understanding other people in a positive way, it'll be easier to live with being assertive yourself. Because if you do it always with human kindness, people will respond to it. And don't stare at them the way I do.
Adriana. Our next question is from Adriana De Leon.
Now, you can ask the question, then come chase me for a picture, okay? Because I can't walk down there and back up again. One way is about my best, okay? All right, but you can ask your question first, so I can think about it as you ask it. Go ahead.
Es un privilegio estar con usted esta noche.
Muchas gracias.
I'm a 3L student, Puertorriqueña, from El Barrio, and also a 1999 graduate of Cardinal Spelman High School.
Oh my gosh. You know, ever since for years I've been visiting Cardinal Spelman, but since I've become a justice, I've gone even more. And it's amazing, it's a totally different school when I was there. The size is much smaller.
Is it?
Yeah.
Oh, well, yeah, they started downsizing when I was there.
Yeah, and when I was there were nearly 2,000 students. It's nothing close to that now, no.
Not at all.
But it's a place that really affected my life, and I hope it affected yours positively.
Very much so.
Yes.
As someone who has achieved great success in your career, how would you advise people like us to go back into our communities and help the students who share our background on many facets to understand the value of a fine education, like the Ivy Leagues or any other top schools in the nation?
Okay. I visit schools constantly and have throughout my entire career. I have not only visited my grammar school and my high school, but I go to schools all the time, all across the country. Most of the time when I'm visiting places, I'm visiting middle schools, high schools, colleges, and universities and law schools. Why do I do it? I do it because if kids don't know what is possible, they can't aspire to anything. That's what education generally is about, is teaching you about what the possibilities are in the world. And so for me, how we make a difference, you and I, is by continuing to go back and being both a role model, but talking to kids, explaining it to them, showing them what the importance is, and opening their worlds for them. You know, I look at every audience of kids and I say to them, you are already light years ahead of me, because you know there's a Supreme Court. When I was your age, I had no idea what that was. And every time you meet someone who's different than you are, who's not from your neighborhood, ask them what they do. Ask them why it's important. Talk to them about how they got there. And almost always, if not always, they're going to say to you, because I studied to get there. And that's how I talk about education, is opening their worlds for them in a way nothing else can. But we have to take our world with us and never leave it behind. You know, I tell people that my family, not just my mother and my brother, but my cousins, my aunts and uncles, my grandmother, they have, and were, when they were those who are no longer living, were living, they came to every institution I've ever been a part of. I was probably one of the few kids at Princeton University whose family would regularly come to visit her, and they slept in the small room I had as a student. My mother was the eldest. When she was the eldest, she would sleep on the bed, and the rest of us would sleep on blankets with pillows on the floor, because no one in my family could afford a hotel room. It was bad enough to afford a bus ticket, but they came. And to every major event in my life, my family has been front and center. To my district court induction, about a quarter of my family was late, and I knew they would be, because Latinos are not very punctual. But they learned their lesson. For the second and third inductions, they were there early. So we learn, okay? When I got inducted to the Supreme Court, and the president held a White House party, they all came. From New York, from Puerto Rico, from anywhere that they were, they came. And at a certain point, I took a break, and I went into the bathroom, and there was my aunt, my then 80-odd-year-old aunt in a wheelchair, sitting by the basin with her pocketbook open, stuffing it with plastic, with the paper cups that had the emblem of the White House on it, and the napkins, okay? And I looked at her and I said, Titi, por favor. Titi, please, okay? Aunt, please. At any rate, she said, Sonia, no se van a fijar, no te apure. They're not going to notice, don't worry. I ran out of there shaking my head, went up to my mother and told her in Spanish, go take care of her, okay? Now, that moment wasn't, internally embarrassing. And I thought it was only my aunt, my family. Well, last year, I was invited to the White House Christmas party, and the president talks to the invited guests at a certain juncture. And he talked to us and welcomed us and did his rest of his speech. And at the end, he just went off script and was joking around with the audience and said to them, don't take the silver, they counted. But you can take the paper cups and the napkins. We know everybody takes them, and we put them out for you. Big lesson that moment was for me. I realized that for all those moments where I thought my family was a little too loud, where they dressed a little bit too boisterously, where they did things that were different than I thought different than other people did, that I was probably wrong. They weren't. Everybody has a crazy Titi Gloria. I describe her in my book. You have something comparable in every culture. Every culture has the relatives who are a little too loud, the crazy ones, the silly ones, the everything ones. Mm-hmm. And that it is important for us to include our family in the way we're growing, to let them see and play a part in the world that we're moving in, and to ensure that they're with us side by side at every step, as difficult as it may be of our new worlds. They may never be able to join it completely, but if they know that we're including them, that we're talking to them about it, not at them, but with them, that they will learn to be at our sides, and we will take them with us. You know, most of my cousins have now graduated from college, and I'm very proud of that. And I think the fact that I did, and my brother did, and a couple of my other cousins of our comparable age did, means that the next generation of cousins is taking it for granted that they're going to college. And that's not something that was necessarily a given for me, but it is for them. And so that's the role we can play. Bring them with you. Nice. You're welcome.
Thank you. The next question is from Brenda Badham.
Brenda, ask me your question from down there and then come up.
Okay.
All right?
Justice Sotomayor, my grandmother also hides plastic cups in her wheelchair. Comments.
So just remember, the president says everybody does it.
So my question also piggybacks off of what you just said. You stated in your book, is disagreement with your brother Junior, you called it domestic politics. Coming from a Hispanic background myself, I know how close Hispanic families can be. So how have you managed such a public position while keeping your family close to you, but out of the limelight or out of the public eye? And also, in which ways has your familial experiences influenced or shaped your rulings?
You know, during the confirmation process, well, no, let me back up. I'll tell a different story, okay? For years, when I saw my mother with someone else, she would start bragging about me. Mm-hmm. And it would mortify me, all right? Every word she said would just make me cringe with embarrassment, okay? And finally, one day, I looked at her and said, "You cannot do this. If you do this, I'm going to walk away. I'm not going to talk to you ever again. You cannot brag about me," all right? And I was that upset more, okay? And that brought some lack of embarrassment for a long period of time. She stopped bragging about me. And then one day, a TV station, asked us to do a documentary about mothers and daughters. And they came to our house, and they started asking us questions, and I started speaking, and my mother was giving basically monosyllabic answers. And I'm like, what's going on? And so I called break. We go into the kitchen, and I go, "Mama, why are you so quiet? You can talk anybody into silence. Why are you talking, not talking?" And I said, "You know, you're supposed to say things, but you're not saying hardly anything. Are you afraid? What's wrong with you?" And she got this little smile on her face, and she looked up at me and said, Payback's a bitch. You told me not to tell. I looked at her and I said, oh boy, mommy, you got me. I said, okay, I take it back. You can say anything you want. She smiled and she laughingly went back into the room and started talking, okay? And started thankfully bragging. So, but we then had a really good understanding. And I said to her, and I talked to her about it and said, it embarrasses me for you to brag about me. And more importantly, you don't know what that other person's situation is. You don't know if they're having difficulty with a child, if something's gone wrong in their life. And when you brag, you make other people feel badly. So I think you have to use some judgment about when you do things like that. And please, if you can, don't do it in front of me. At least you can do it, but not when I'm in front of you, okay? And we actually have had a perfect relationship over this issue since. She's really very good. So even when we went to plan her will, and the lawyer, I was a Court of Appeals judge, and the lawyer looked at me, because I had just given him my name and said I was a judge, but not what kind of judge. And he looked at me and he said, well, are you a traffic judge? I could feel my mother about to say something. And I went like this and grabbed her arm. And she said, afterwards she said, why don't you say something? It wasn't necessary. He didn't know who I was. I didn't care. I just needed information from him and for him to do something for us. So, you know, there was no need for you to brag and no need for me to say anything. He may feel differently today, but I don't know, okay? So how do I do it? It took me a long, long time, and I describe a lot of this in my book, for me to learn how to be more open with people. But it took me longer to do with my family and my mother than it did with strangers. I was more open and vulnerable with my friends in telling them about the things that were moving me in life and troubling me in life than I ever was with my own mother. And certainly with my own family. I was much, much older in life before I could learn that I could trust them to love me, both through the good and the bad. When I could tell them how I had messed up or what I had done that I was ashamed of, or the things that had broken my heart, or the things that were weighing on me, before I could learn to talk to them about it. And sometimes their reactions weren't what I hoped for. And sometimes I know I said things that they really didn't fully understand. But the fact that I shared it with them, I think gave them a greater sense of belonging and of a greater sense of knowing not just how much I valued them, but how deeply I appreciated that they valued me too. Because it's a mutual relationship. But it takes a long time to get there. And a long time for them to say to you, I was uncomfortable. You know, and I've had my mother in certain situations come back with me and say, they didn't really pay any attention to me. And I could hear the pain in her voice, like, you know, they were a little bit rude to me. Not anymore, now that I'm a Supreme Court justice, they don't do that anymore. But before it did. And to talk about things is often the only way you can get them to do that. And that takes your courage. And you're growing into a place where you're more comfortable with yourself so that you'd be more comfortable with them. So good luck with it.
So while you take your next picture, we can have the next question, which comes from Corey Reisman, down here on the floor.
Hello.
Go ahead.
As a second-year law student, one of the things I've learned is that law students are some of the most passionate and opinionated people I've ever met when it comes to legal, social, and political issues. As a person whose position requires them to be impartial and unbiased, but also places you in a position to make decisions that affect millions of people, when you're on the bench, how do you generally reconcile your own personal convictions and beliefs with your responsibilities of remaining neutral, unbiased, and impartial?
Well, I don't think there's anything wrong in being sympathetic to something that requires sympathy. We're not. If you've heard that someone has been hurt, physically, emotionally, psychologically, as a lawyer on either side of the issue for that person, or you've been hired to defend the position against that person, acknowledging that person's injury doesn't diminish you or your argument, because hurt is hurt. And saying to someone, whether I'm on their side, you don't have to follow me, I know. You can stand there.
You can come back, Claire. We got a seat for you down here.
It doesn't, there is nothing wrong with a judge who reacts to a situation by saying, isn't that horrible? What happened to that person is not a good thing. It's not something that I'm proud of as a judge or as a human being. But that's different than as a judge saying, does the law provide a remedy for that hurt? And engaging that person's lawyer in explaining how the law does that and questioning them about the limits of the law and its ability to remedy that particular situation. I don't know that as a judge that I have to either hide my human reactions or stop myself from probing the strengths and weaknesses of any legal issue because it evokes emotion. We do that all the time when we're having discussions with people. Have you ever heard of a really horrible situation where you've not said, that's really terrible? And if you haven't been able to do that, then you're a pretty cold human being. And if that's what you want a judge to be, you should ask yourself, what's the value of that? All right? But it could be a really horrible situation that the law doesn't provide a remedy for. And I'm not the lawmaker. I'm the law interpreter and applicator. And to the extent that I'm unable to look at someone who's hurt and say, I can't help you, and this is why I can't help you. And I understand why this feels badly to you and why this is bad for you. But this is why the law is doing what it's doing in this situation. If I can't do that, then there's something wrong with me as a judge and a lawyer because I have not been able to articulate the reasoning of the law. And so I guess what I'm saying to you is, if what you think neutrality is heartlessness, then I disagree with you. If you think what neutrality is a judge being able to say, if I chose and I were God, I would do this, then I agree with you. That's not the kind of judge I want. I want a judge who will be able to say, I choose because this is what the law requires. And that, if you don't have that kind of judge who can say, this is what the law requires and I'm doing it even if I don't like it, then that's what a neutral judge is.
I'm terribly dismayed by how quickly the evening is coming towards an end. I think we
So
can
unless you have to pay for the room, I'll go a few more minutes.
All right. No, All right, so our next question then comes from Marianne Crisa.
Oops. Hello.
Hi, my name is Marianne Crissa, and I'm a 1L. Politics often evokes strong emotions, and that certainly seems to be the case at this particular moment in time. Throughout history, anger has driven political movements. It can be an extremely powerful tool in any movement that demands rights for people whose rights are not recognized. On the other hand, political diplomacy and compromise have also been powerful tools for movements that seek the recognition of rights. On the Supreme Court, you've described the process of judging as a very collegial one, but anger sometimes plays a role in the judicial process too. It's sometimes what gives people the energy to pursue their rights in court, and sometimes it's what drives a judge to write a dissent. Do you think anger ever has an appropriate role to play in the judicial process?
I don't think unchecked anger has a role to play in any process. When you are letting anger out without controlling it, then all you're doing is letting emotion rule. And for me, I don't think that's positive in any human interaction. Uncheckered anger, in my judgment, is self-indulgence. Because all you're doing is spewing out your venom for no purpose. If you're talking about pointed anger, right? Anger that you recognize as anger, anger that's serving a purpose, and that you're utilizing as in a directed fashion, that has value, okay? That has a significant, in my judgment, a significant amount of value, and has the value of serving a measured end. And so some would call protest controlled anger and an expression of controlled anger. And protests have, through our history, proven very effective in getting people to pay attention. You can have controlled anger in writing, and sometimes you read passionate dissents and you can see the underlying anger, but it's there for its own purpose. Generally, among colleagues in a collegial court, it's rarely effective to express person to person. Because the one thing that gets people to listen is your passion about an issue, but not your anger about it. There's a big difference between the two. And yes, pointed passion has its place in a collegial court when you're talking to each other. But it won't if you're angry, because what people will do is sit down and become silent. And silent usually won't get you agreement. And so I describe the two things as very different, and the effect that they can have is very different. But in a collegial court, if you respect that the other side is as well-intentioned as you are, that's why the Supreme Court gets along so well, because we know we disagree, but we know that we all share an equal amount of passion about the law, about our system of government, about the Constitution. We can disagree about what we think the best answer is to promote those things, but it's all born from the same dedication to the betterment of the law. And because I understand that, I can disagree with my colleagues. I can be angry at them at times. I want to shake them and tell them, why don't you see this my way? But in the end, I respect that they're not motivated by ill will. They're motivated by seeing things differently than I do. And that's much more effective to engage that. So. All right, how many more students do we have?
We've got Sydney Taylor with the next question
Okay.
over here. How about that?
Hi, Justice Sotomayor.
Hello.
My name is Sydney Taylor. I'm a 2L here, and I sit on the e-board of the Black Law Students Association. I have a lot of conversations with my peers where it feels as if I'm essentially trying to persuade someone to shift their perspective on some of their fundamental views. For instance, I find myself in conversations trying to persuade people that racial and gender bias are still pervasive in American society, and some people have a strong negative reaction to that view. How do you go about trying to persuade your colleagues to accept things that go against their basic understanding of how the world works? And have you yourself ever been persuaded to change a fundamental view on something?
Let me answer your first part first, okay? Your last part first. I was blessed being a state prosecutor with a boss who didn't believe in the death penalty, Bob Morgenthau. He's retired from being the district attorney of Manhattan, and part of the issues that he's still working on is working on getting the death penalty repealed. Okay? So he's a almost 98-year-old man. He's going to make it to 100. We just celebrated his brother's 100th birthday a few months ago. And his anti-death penalty sentiments are notorious. I felt that way when I was a DA. And I had to confront my emotional and well-substantiated feelings about many of the things Bob Morgan talks about, which is the unequal imposition of the death penalty and the cost to society. There's a lot of strong arguments that people should consider on this issue. But when I became a judge, I had to deal with the question of whether I would enforce the death penalty. And I had to think about that. And I had to put myself in the position of people who do believe in the death penalty and the people who do believe that it's justified because some crimes are so horrific that nothing else but the death penalty can articulate society's negative reaction to the nature of particular crimes. And having prosecuted some cases where I actually met some really bad people that were incorrigible, I understood why it was important for me not to bring my personal feelings into my jurisprudence as a judge. So that I could honestly say, when asked, would I enforce the federal laws on the death penalty? And I do. Now, some of you may have written some decisions where I have questioned some death penalty laws and some death penalty processes, because I'm a judge, but that doesn't and shouldn't stop me from ensuring that we apply all laws with due process. And I still will do that. But there are many, many, many cases for review of death penalty cases that come before me where I don't vote a dissent, where I vote with the majority. And I do that because my values were shifted from experience and from reading and thinking about an issue in a different way. And so fundamental values can shift, but it takes a while for the understanding of the reasons why for people to come to those things. Have you ever, I tell kids all the time, do you sometimes talk to your parents about something and what do they say to you first time? No. They talk about 2-year-olds? Think about your parents. That seems to be their favorite line for a lot of their life, okay? And your life with them. And you talk with them today, and you try again tomorrow, and you try again the next time, and you try yet again. And eventually, somebody brokers a compromise, okay? What made that happen? The talking. The talking it through, their understanding of the passion of the issue for you. They're talking sometimes to other people who have said, you know, it's not quite as bad as you think. And in the end, they move. You move. You're not going to stay out till 3 in the morning. But maybe they start letting you stay out till 11 and then 11:30 and then midnight. And then on prom night, they let you stay out a lot later. All right? But if you stop talking, there's no chance for change. If you stop trying to explain, with time, people may grow to understand. And so for me, that talking, that engagement, that explanation, the providing of examples, that's what my book was about. I mentioned many of the incidents of discrimination that I had endured and had been subjected to, and try to get people to see it from my side. And perhaps if they could, they might understand why the marshal who called me honey, even though he didn't mean to, he was still offending me. You know, and he didn't really mean to offend me. But it's important to understand why when I was in a room full of lawyers, all of them male, and one of them turned to me and said, "Go get us coffee, honey," why that I would be insulting to me. And why the senior partner who looked at him and said, "No, she can't, she's a lawyer. I'll order some coffee." Why he made me feel so good. And why he took a stand that others should in similar situations. But we gotta talk about it. Don't give up. Because people do change, it just takes time.
Well, I
I
can't
got a
stop.
picture with you, all right?
Oh, yeah, you did? I can't stop the
will, but
conversation
then
when your
who
last
did
answer
ask?
was stop talking.
You two didn't.
That's
I
right.
want pictures with them, would you? So you gotta stop, I'll stop.
You
But
can,
after
you
I
can
the
take,
picture.
well, you're the justice, I'm not gonna tell you.
You do what you want. At least in your pictures.
Thank you. Thank you.
All right, I think, Thomas, we can take one more question if you're, can we get the microphone for Thomas?
We can do it.
Thank you. Thank you. You guys too, or just front row, right? Okay, thank you guys.
My question was, what, in your opinion, can current law students, lawyers, judges, and even Supreme Court justices do to increase faith and trust in the judiciary at a time when faith and trust in that institution seems to be ebbing away in our country?
Talk to people about what we do. You know, Dean, you haven't asked me this question today, so I'm going to tell you anyway. Okay? I'm often asked what law schools can do better. I start with one bit of advice recently, and I stole this idea from someone else, but I think it made a very good point. Why is it that we're teaching ethics in the third year?
Should be earlier.
All right? Why is it that we're preparing people for an ethics exam at the end of their time in law school as opposed to the beginning? Because the issues that young lawyers will face with ethics questions should be at the forefront of their minds at the very beginning of their legal training. They should be engaging in those conversations with each other and with you as professors from the very beginning of their time in law school. And, more importantly, no lawyer should leave and graduate from law school without being passionate about being a lawyer. Anyone who talks to you about the bad lawyers do, you should be able at an instance to tell them all the good we've accomplished, because there's so much of it. Don't ever let anybody tell you a lawyer's joke, and one where they're criticizing lawyers. When people start, I look at them and I say to them, why do you think we have all these laws that help people? It's because lawyers protected people's rights and made others understand what we needed as a society. There's so much criticism about tort law, and I sit there and I say, there's a lot of reform we can do. I'm the first one to talk about that. But understand that tort law is what's kept products from blowing up when you've used them. All right? It's what sensitized companies to understanding that they should test their products before they test them on you. All right? There's always reasons for laws. And generally it's because laws want to protect people. And so for me, that passion is what we need lawyers to have. We should never be apologetic about the good we do for people and for society. We should be proud of it. And we should be passionate about the roles that lawyers play in helping society and people. And if we could show that passion and communicate it to people, I think there'd be less distrust of lawyers and more respect for the law and for what judges are trying to do. And I'm the first one that look at people and say, when you don't like a decision we've rendered, how often do you read it? How often do you actually try to understand what motivated a judge to come to a decision they came to? And I can assure you that it's been never that I've had a person who's disagreed with a decision tell me they've actually read it. All right? And so if you can disarm people that way, you start them and you say, if you read my thinking, you will understand that there were actual reasons I came to my conclusion. When you can be in a place to talk with me about those reasons, then we can have a real conversation. And that's what most of the time we should challenge people to do, engage with talking with us, not with the emotion of the outcome. Because that's what's motivating most people's reactions, the outcome, and not the reasoning. If you point out to people that in a lot of cases, people from different backgrounds have come to the same conclusions. As someone recently pointed out, Justice Thomas and I agree 60% of the time. There's a lot in law where you can come easily to agreement around, but there's the more contentious issues that require a different perspective and a different approach that lead people to different conclusions. And there we may disagree on a lot of fundamental things, but it's because we have a different approach. And if you don't understand what our respective approaches are, you really can't talk about what the basis of our differences is. But most people react to conclusions, not process. And that's what lawyers and judges are doing. They're working within a process. And to understand that process is to understand why different conclusions are very, very possible. That's why circuit courts disagree. That's why judges can disagree. And that's why you want a bench where there is disagreement. Because you want to ensure that the final answer is as right as we can get it after having heard as many voices as we have.
And with that, can we all give the justice a big round of applause? Thank you.
Stay with us for a minute. We've got something for you.
I'm going to bring up two of our professors, the chair of our Stoneman Committee and our Stoneman chair, Professor Melissa Brieger and Professor Mary Lynch, to give the Stoneman Award to Justice Sotomayor.
Oh my God. Oh, I still have mine, but it doesn't fit anymore.
I wasn't sure if it was born Mary.
Justice, it is a true pleasure and privilege to be honoring you today, one of the most esteemed jurists of our time. The Kate Stoneman program is an integral part of Albany Law School. Tonight you join our prestigious circle of Stoneman folks that now brings the total number to 75. At this time, I'd like to ask those in the audience who have earned a Stoneman Award to please stand and be recognized.
I'm in amazing company.
You, in fact, are. Now, I've always read and taught your opinions, especially many of your dissents, with great pleasure. One of the justice's most famous thought-provoking quotes that I think is especially fitting for tonight, and I know it's especially fitting now for me, I have a new role model. She says, "A role model in the flesh provides more than inspiration. His or her very existence is confirmation of possibilities one may have every reason to doubt, saying, yes, someone like me can do this." Both Kate Stoneman, a role model in her day, and Justice Sotomayor, a role model for so many of us today, allow the rest of us to follow the paths they have bravely paved so we can walk in their footsteps. With so many parallels in the pioneering and trailblazing spirits of these two women, we at Albany Law School are so delighted and grateful to be able to award you the 2017 Kate Stoneman Award. It is now my pleasure to introduce another role model of mine, another strong spirit who hails from the Bronx, who hails from Cardinal Spellman High School. I introduce the newest chair, Kate Stoneman Chair in Law and Democracy, to bestow the award upon you.
So, about 130 years ago, just a little over 130 years ago, Kate Stoneman broke the barriers for every woman ever admitted to the practice of law in New York State, including those of us here. She simply would not accept arbitrarily limits imposed upon her. Similarly, Justice Sotomayor, at each stage of your rise, from the schools of the Bronx to the highest court of the land, you did not accept arbitrary limits, not for yourself and not for any other sister or fellow human being. And we have all benefited from your keen intellect, your inspiring mentorship, and your wisdom born of a most beloved life experience. So on behalf of the entire Albany Law School community, for your extraordinary achievements, for your inspiring mentorship, and for your fierce commitment to fairness and equality, I am so, so proud to bestow upon you the 2017 Mimi Netter Kate Stoneman Award.
Okay, and before we let you go, as some of you know, we're really close, I swear. We just can't bear not to do this.
Can I say just one thing? Kate Stoneman was someone whose footsteps I have followed. But mine are not ones that I want people to follow in. I want them to join and make them with me. So I invite every woman and man in this room to know that the light she lit is for all of us. And we should be doing this together to raise the banner of equality as high as we can and to lead under that banner to new and better places for all of us. I am honored to receive this award. Thank you.
Okay, so on behalf of the next generation, as some of you may know, there's a tradition among judges and justices who care deeply about the people who work for them, and nobody cares more than this person here about the people who work for her, of referring to the children of their clerks as grand clerks. So here to give you a special present on behalf of the next generation are your grand clerks, Violet and Evelyn.
Thank you. The bears are going to sit on my shelf. It's very low, with toys for every grand clerk who visits to play with. Thank you.
Nice. Thank you. Thank you, sweetheart. Thank you. I can hold those for you if you want. I'll give them back, I promise.
Okay.
I'll give them back.
He promised.
I'll give them back, I promise.
We're almost done here. So at Albany Law School, we're proud of many things. Many, many things. One of the things we're proud of is that we have a basketball court at the heart of our law school. And
I was there.
You were there, and many of our students and illustrious graduates have played basketball in that court, and we want you to remember us. And so we have for you an official Albany Law basketball. You're welcome.
My big kids, the big law clerks will play with it.
Excellent.
Thank you.
And that concludes our program. Thank you so much, Justice.
Thank you.
We'll never forget.
Thank you so much. Thank you so much.
We figured you're not getting that from another law school.
I have a football. Now I have a baseball.